Hi, guys. Thanks for being here.
Good to
Good
see you.
afternoon. Good seeing you.
We're going to talk about this case where I think the association got the short end of the stick and they lost this case. Obviously, what do I know? But it's about how a home was classified as a single family home when in reality it was obviously made into a two-family. You'll talk about the legalities of it. So before we get started, let me have you introduce yourselves, and I'll start with John.
Hi, John LaGumina from the LaGumina Law Firm in Purchase, New York. We're in Westchester County, and we represent homeowner associations, condominiums, and co-ops from New York City throughout the Hudson Valley areas.
Sean.
Good afternoon. My name is Sean O'Connor. I'm an attorney as well. I'm a shareholder with the law firm of Clarkson, McAlonis, and O'Connor. Our office is in North Charleston, South Carolina. We have a statewide community association law practice with clients all over South Carolina and all regions of the state, and we handle general counsel services, collections, and construction defect litigation.
John, I'll start with you. So the way I see this case is that, like I just stated, there was an individual. The lawsuit was against a woman. She was the defendant, or maybe she was the person suing. You'll correct me on that. And she basically made her home into a two-family home with a kitchen and a whole bunch of different kind of plumbing. And the association fought her and lost. And the reason why I think this is important is I could see this happening to our audience. So why don't you kind of take it from there, John, and explain the circumstances?
Yeah, so actually the parties were the other way around. She was the defendant and the HOA was the plaintiff. But long story short, she built something that the HOA felt was clearly against their covenants. You know, depending on the state, in New York there would be your declaration and your bylaws. Some states call them master deeds, etc. But the point for any state is when you're dealing with what we call architectural review, ARB type of compliance issues, while courts will uphold an HOA's architectural review rights, they will also interpret the governing documents pretty strictly and narrowly. So in this case, they looked at the actual wording and felt that the definitions of a single-family dwelling didn't really rule out what the defendant in this case had built. And the takeaway is not just be careful of how a court interprets it, but I think for me especially, the takeaway is this probably the lawsuit the result could have been flipped around and either avoided or won is if they actually had tailored and amended their governing documents to appropriately deal with this situation, which they were aware of. Because I see here in some of the fact patterns that they were dealing with not just the original governing documents, but restated and amended documents, which suggests to me that the community had reviewed their original documents and significantly changed them.
John, she took a single family home, and according to the article I read, it had added an addition, basically, with separate sleeping, sanitation, a kitchen. It was basically converting a one-family home into a two-family home. It was extremely obvious that she did so. And I don't see how the association was wrong in saying there's no way you should be able to get away with this, but she did get away with it.
Yeah, because the court actually looked at the definitions and said that the HOA didn't demonstrate that there will be more than one household in the home. So even though it was possible, it didn't necessarily mean that there would be two families there. It's a little bit of a really strict reading of it, but my experience with restrictive covenants and rule enforcement, courts will look at it very carefully. So you really need to think carefully and tailor your rules. If you're restating your bylaws or declaration, and consider the type of issues that come up, and just, you have to really be careful how you word your regulations, because you might not be able to enforce them, which is what happened here.
And Sean, I'm going to go to you in one second. Basically, John, they lost just because the wording was wrong in their governing documents.
Pretty much.
So for our audience, they may want to look very closely in regard to the wording for their governing documents, because they could find themselves in the same boat with a single family home basically being turned into completely a 2 single family home.
Yeah, I mean, if you want to ban that type of arrangement, then just look at, like, craft a restriction that makes that very clear, and what you can't do. And it may even help when when you draft these covenants. You could even put an example in and say, for example, you can't do this. There's no reason why you can't clarify it by doing that.
So Sean, they had all this in their governing documents already. It just wasn't good enough. I'm assuming they thought they were covered, that this couldn't happen. And lo and behold, it happens. And when I came to you about this article, Sean, I was surprised that you told me you had another case of this happening, I believe in South Carolina, correct?
Right. So on this case that John just discussed, it's Clover Meadows versus Spear. It's a Montana Supreme Court case, but it's important to note, as John indicated, that this principle is a broadly applied principle of law that is pretty much going to be the case in all the jurisdictions. And what it comes down to is that anytime a court is asked to interpret a community association's governing documents, the phrase at issue that's being litigated, that is the source of the dispute, it's going to be construed against the association because it was the association that drafted it, and also because the law favors the free use of property. So if there's any ambiguity at all, in other words, if the key language that is the source of the dispute is capable of more than one reasonable interpretation, then the court is going to always side with the homeowner, and favor the free use of property. And the problem with this association's governing document at issue is that all it said was, there shall be no more than one single family dwelling on any one lot. And there was a lot of evidence that made that unclear. For one thing, the people that were living in this addition that Mrs. Spear added to her house on the other side of her garage, it was not rented to a third party for rent. It was her parents, like her children's grandparents, that were staying there. So that allowed the homeowner to say, we're all one single family. Okay, so that's one thing. The other thing, as John mentioned, that there was an amended version of the governing documents that attempted to clarify and be more specific about these issues, but those were not the ones that were enforced when the Spears applied to put this in and built what they built. And it also said that, they had to go and ask for approval and permission from the Architectural Review Committee, which there was no Architectural Review Committee in place at the time that they made this application. So there's a lot of missteps looking back on it that caused the association not to be able to get its way. But the main one was that it just wasn't clear enough and specific enough as to what is and is not, makes it a two-family residence. For instance, like Ray, you mentioned the thing about the kitchen and laundry, they stubbed those things out, but to help them win the case, they didn't actually put the stove and the, additional laundry facilities and all that in there. So, these were just all gray areas. And whenever there's a gray area, there's a great likelihood that the association is going to lose because the law favors the free use of property.
There's also,
and like you mentioned, I'm sorry, go ahead.
No, you go ahead.
Yeah, so this was a 2024 case, this Montana case. There was a relatively similar case in South Carolina, not as recent. It's a 2017 case, but it's on Hilton Head Island, the community association on Hilton Head Island. The case is called Community Services Association versus Wall. And what happened there was the family that owned the property wanted to rent their property on Airbnb, and the covenants did not specifically prohibit renting property, but if you were going to rent the property, you had to rent the entire property and not just part of it. In other words, you couldn't have a guest suite or anything like that and rent that as part of the home. And so when the association contacted the Walls and said, hey, you've got this guest suite and you're renting it, and that's against our covenants, you have to stop doing that. What they did was they went and lived in the guest suite and rented the rest of the house. And the outcome, so that sounds kind of crafty, like they're just kind of trying to get around a covenant. But what ended up happening was the same thing that happened to Clover Meadows in Montana. Our appellate court in South Carolina reviewed the covenants and found that the language that regulated rentals was not specific enough. It was not clear. It was capable of more than one reasonable interpretation, and therefore, because the law favors the free use of property, the HOA lost, and the Walls were able to do what they wanted to do, which is live in their guest suite and rent out the rest of their house. And the HOA was not able to prohibit them from doing that. So kind of the same lesson, the same outcome, which is, if you want to do something, in your covenants to restrict what homeowners can and can't do with their property, it's a good idea to go over those with your general counsel and make sure that it's clear and specific enough. Otherwise, if you get into a dispute about it and there's an issue of interpretation, there's a good likelihood, if it's capable of being interpreted more than one way reasonably, that the association is going to come out the loser.
John, I love this part too about, I guess a lot of associations have commentary in their governing documents about related by blood, right? Because look, people aren't making governing documents always they don't want to like screw people over, right? We're all humans, and they look at something and they say, hey, what if somebody wants their elderly mom or dad to move in? We don't mind if that happens, and maybe they could have a small section of the home if they're related by blood. But to me, that opens up a whole can of worms, because what does that actually mean, related by blood? How far does that go? And I know there's associations that contact me that they have scenarios where people are related by blood, but there's like 30 people in the house.
Yeah, I mean, again, Sean mentioned it, and I'll, if it's subject to various interpretations, what does it really mean in ambiguities? It may not hold up. So yeah, the takeaway clearly is you really have to, especially if it's an important covenant that you want to enforce, you have to think about it, think it through. What do we want to cover? And another takeaway from at least the Montana case is they got the defendant got a significant attorney fee award. There's an attorney fee clause. I guess in Montana they must have a reciprocal. So the attorney fee clause there only was in favor of the HOA, but by law that's deemed to be reciprocal. So she actually got I don't know, like almost $40,000 in attorney fees.
So if you're in the audience and you're saying to yourself, I don't need to worry about this, it's never going to happen to us, well, I would think twice and maybe double check those governing documents with your attorney, because there may be a very good chance they need to be updated. Can I leave it there, guys?
I think that covers it.
Yes.
All right, well, thank you.